To understand the Patents Act, we can look at the timeline of the grant of a patent. The timeline can be defined or described in the form of a diagram. The starting point of the timeline is what we refer to as TA, that is the time of application of a patent, and the end point of the timeline can be explained as the time of expiry of the patent. So, the life of a patent is actually between these 2 points. It is between TA and TE. On an ideal case, when a patent is granted, it can survive. The patent has a 20-year term. So, TA to TE in an ideal case is going to be 20 years. So, 20 years is the patent term, and we have just described this timeline for you to understand how we can understand the Patents Act as provisions which can be shown or which come into play between these 2 timelines. So, the entire Patents Act, the enactment that governs the law of patents in India, can be understood as interventions between TA, that is time of application, and between TE in the life of a patent. Now, let us see how that looks. The patent normally takes on an average 3 to 6 years for it to get granted. So, from the day you apply the patent, that is from TA up until TG, that is the time for the grant, you have roughly, and this is not set on stone, it varies from application to application, and it could also be it could vary from patent office to patent office. So, on an average we could say that the time between filing the application, the time of application, and the time of grant. The grant is when a patent is granted by the patent office. So, this time period takes roughly 3 to 6 years, and the sections in the Patents Act that govern this stage, that is from TA to TG, are largely sections 1 to section 81. Okay. 81, so when we refer to the events that happen between TA and TG, we are also looking at certain events that happen immediately upon the grant, upon TG. So, it is not just the time for the grant, but also certain events that can happen immediately upon the grant or soon after the grant. So, if you need to draw a line demarcating the patent office's functions, then it will be around section 81. So, anything before section 81, that is section 1 to section 81, are events that happen at the patent office up until the grant or soon after the grant. From TG to TE, that is soon after the patent is granted by the patent office, the patent has its remaining life, and this time period is what we call the time in which a patent is enforced. Patent enforcement happens between TG and TE. Now, when we say patent enforcement, we are referring to the patentee, the right holder, the patent holder exercising his right in the patent. Now, that could come in the way of licenses. When a patent is granted, the patentee has the right to license his technology, license his invention. It also pertains to measures that the patentee can take to prevent others from interfering with his right. So, when somebody else interferes with his right, we call that an infringement. An infringement is an act that intrudes into the right of a patentee. The patentee is granted certain rights under section 48 of the Patents Act. He has a right, an exclusive right to exclude others. So, it is a right to exclude actually. He has an exclusive right to exclude others from making the invention, from selling the invention, from offering for sale, from importing, and for using the invention. Now, the invention can be a product or a process. These details are mentioned in section 48, but largely any intrusion on these sets of rights by a third party without the consent of the patentee is what we refer to as infringement. So, infringement and licensing. A licensing is a positive act where the patentee allows his invention to be used by others, in most cases for a royalty, and and infringement action, which is an action taken by the patentee to stop persons who do not have his consent from using his invention. These two acts can together be called patent enforcement, the way in which a patent is enforced. Soon after the time for grant, there is a proceeding that can take place in the patent office, which is called a post grant opposition or opposition after the grant. The language used in the Patents Act is opposition after the grant, but it is in common parlance it is also called post grant opposition. Though post grant opposition happens immediately after TG, that is 1 year after TG, that is the timeline for the post grant, the provisions of post grant are mentioned in section 25. So, that is an exception to this middle line that we have told you, that anything before 81 pertains to patent prosecution, things that happen in the patent office, and anything between TG and TE, that is section 82 to 160, that is the so section 1 to 160 covers the entire ambit of the Patents Act. So, anything between 82 to 160 will happen outside the patent office. So, this timeline has some exceptions. One exception is what I mentioned, post grant opposition, which happens soon after the grant. So, that is why I qualified my statement earlier saying that the timeline between TA and TG should be understood as events that happen at the time of grant and soon after the grant. So, to recap, TA to TG are events that happen within the patent office, and when we say TG, we are also referring to things that happen soon after the grant too. So, the patent office can look at certain things that happen soon after the grant or which are related to grant. For instance, compulsory licensing can happen any time between TG and TE, but still because it is a procedure at the patent office, you will find that it is mentioned after section 82, but nevertheless it is considered as a patent office procedure. Now, the events that happen between the timeline between TA and TG normally happens at the patent office, and the events that happen between TG and TE, that is the time of grant and time of expiry, could happen before the district court, before the high court, or before the IPAB, that is the Intellectual Property Appellate Board, the board that sits in appeal over decisions of the patent office. Now, let us look at a rough list of things that happen between TA and TG, because if you are going to take the patent agent examination, then the patent agent examination largely focuses on this part of the Patents Act, though there will be questions on what happens between TG and TE, but largely it is going to be between section 1 to 81 with some exceptions too. We will cover the exceptions later. The events that happen at the patent office between the timeline TA and TG are referred to as patent prosecution. Now, during this timeline, you have the sections in the Patents Act deals with a variety of things. Patentable inventions are described in sections 3 to 5. Patent applications are referred to in section 6 to 11. The procedure for opposition is mentioned in section 25 to 28. This includes pre-grant and post-grant. Post-grant is something that happens at the patent office 1 year after the grant. It can be initiated within 1 year period after the grant. Then you have the provisions on anticipation, the exceptions to anticipation in sections 29 to 34. We have secrecy provisions in sections 35 to 42. Then the grant of the patent, there are sections covering the grant, because grant could be seen as the TG starts with the grant, but there are provisions which go beyond the grant too, because we mentioned that things that happen upon the grant and soon after the grant could come under the TG. So you have grant of patents covered under sections 43 to 53. Then we have amendment at the patent office, that is section 57. Then restoration of lapsed patents for non-payment of renewal fees are covered, again a procedure at the patent office. These are covered in section 60 to 62. Then the patent office maintains a register of patents that is contained in sections 67 and 72. then the Patent Office has certain powers and functions. The structure of the Patent Office, these are covered in sections 73 to 76, and the powers of the controller in general are covered in sections 77 to 81. Now, this is not an exhaustive list, because as we mentioned before, patent prosecution can also go beyond section 81 in few cases. The exceptions where the patent prosecution can go beyond section 81, or rather the exceptions where there are certain acts between section 1 and 81 which do not pertain to things that happen between the timeline TA and TG, are the following. Post grant opposition under section 25(2), though it comes between sections 1 to 81, it actually happens after TG. Though at the Patent Office it happens, the time for it occurring is after TG, because a patent to be opposed under post grant opposition, it has to be granted in the first place. So, you find that post grant opposition is an exception in the sense that it is an event that happens after the grant. So, it comes after TG. Similarly, patents of addition, though it is mentioned under section 54 to 56, which again comes within the sections between 1 to 81, are events that happen after the grant. You could only file a patent of addition if you have already filed a patent in the first place. Amendment under section 58 is not an amendment that takes place before the Patent Office. It is an amendment that can take place before the Intellectual Property Appellate Board or the High Court. Though it comes within sections 1 to 81 in the scheme that we had mentioned, amendments are at the IPAB or the High Court happen after TG. Surrender and revocation, which are covered in section 63 to 66, can happen only after the patent is granted. Again, these events happen after TG. So, on a whole, TA to TG is governed by sections 1 to 81. You have few exceptions where the sections between 1 to 81 may have its impact after TG, after the grant of the patent. So, this timeline, the timeline between TA to TE, the time of application of a patent to the time of expiry of a patent, can be used to understand the entire syllabus of the Patents Act. So, you have broadly sections 1 to 81 covering the events up unto the grant, what we refer to as TG, the time for grant, and soon after the grant you have sections 82 to 160 which cover the events that happen after the grant. The events between TA and TG are referred to as patent prosecution, things that happen at the Patent Office, and the events that occur between TG and TE are referred to as patent enforcement, events that happen in the District Court, the High Court or the Intellectual Property Appellate Board. We just saw how the Patents Act can be understood by looking at the life of a patent. The life of a patent starts with TA, that is the time when a patent application is made before the Patent Office, and it expires ideally after a period of 20 years at TE, which is the time for expiry of the patent. Now, this timeline is mimicked by the Patent Act itself. The Patent Act, the initial sections start with how to apply for a patent, and towards the end the Patents Act talks about powers of various authorities involved in the patent system, and it also talks about how the government can acquire and use. So, you have the entire Patent Act structured around the life of a patent, and the life of a patent, as we had shown diagrammatically, is described as events that happen between the time for application of a patent TA and the time for expiry of the granted patent TE. The Patent Rules 2003 also follow the same pattern. The patent rules are nothing but details of the provisions contained in the Act. The rules describe the details of the provisions contained in the Act. So, the Act follows the same structure. Since the Act follows a particular structure, the rules also follow the same structure. So, if you look at the index of the rules are also structured in the same manner. So, you could also classify the rules the way in which we have classified the Act, as something beginning with application and ending with expiry.